morning. Apologise for the fire alarm. I assume it's a test. I think you should wait until we see if it is a test, Ms. Trainer. Ah, thankfully. Yes, good morning again,
Good morning. Thank you, my Lord. My Lord, this morning we have a panel from the Legal Services Agency.
Good morning, all.
Good morning.
Welcome. Yes, when you're ready, you're going to be asked some questions, I think, as you appreciate. Ms. Trainer.
Thank you. I wonder, a sensible place to start might be if each of you introduce yourselves with your name and your current role at the organisation, and we'll start with yourself on my left.
Good morning.
Good morning.
I'm Alia Sayal. I'm the Chief Executive of Legal Services Agency, and I've held that role since December 2019.
Cool.
Morning. My name's Alistair Houston. I am a solicitor with Legal Services Agency and the head of the Housing and Court Department. I've worked there since 2011 and been responsible for the running of the department since 2016.
Morning, Aileen Miller. I'm a solicitor with Legal Services Agency. I'm a solicitor within the Mental Health Department, and I'm also one of the partners. I've been employed with Legal Services Agency since 2021 and held the role of partner since 2022.
Thank you.
And both Alia and Alistair, you've indicated, I think, that your roles were throughout the pandemic, but Aileen, I wonder if you could tell us what you were doing at the start of 2020 and whether that's similar to your current role.
At the beginning of the pandemic, I was employed by another firm of solicitors. So I was actually recruited by Legal Services Agency throughout the pandemic. I joined the organisation as a solicitor just within the mental health department, and as I say, gained the role of partner in October 2022.
And the previous role that you held as a solicitor, was that in the same area in terms of mental health?
Yep, I dealt with clients who were detained under mental health legislation. I also dealt with some clients under kind of asylum and immigration law as well.
And you've said, Alistair and Aileen, that you both are solicitors, legally qualified members of staff. Alia, you tell us in your statement, I think, that your background is in management and governance of third sector organisations generally. Can you tell us a bit more about that?
Yes, certainly. So I've worked in third sector organisations for 29 years this year, and have held senior management positions for 20 years of that time. So that's providing overall strategic direction, working with boards of directors for effective governance, and supporting teams in terms of operational and financial management.
Now, each of you have given a separate statement to the inquiry which will form the basis of your evidence today. I'm going to read the numbers of those statements just for our records. The first one for Alia is SCI WT 0383, 5 zeros and then a 1. The second for Alistair is SCI WT 0549, 5 zeros and then a 1. And Aileen is SCI WT 0379, 5 zeros and then a number 1. Now, Alia, I wonder if it may make sense to start with you and ask you to explain what the Legal Services Agency is and what you do.
Certainly. So Legal Services Agency is a law centre. We're a registered charity. It was established in 1989, so going for 35 years this year. The law centre focuses on providing legal advice and representation in areas of social welfare law. So by that I mean housing and homelessness. It covers also criminal injuries compensation, disability discrimination, employment law, and the Mental Health Department covers representation people that are detained under the Mental Health Act, guardianship work, both welfare and financial, and power of attorneys. I think that's all the areas of law that I've covered. Aside from providing frontline advice and representation, we also work on looking at trends through the casework that we undertake to influence adverse policy changes and or respond to consultations and or undertake any research capacity permitting. And then the final element of our work is legal education. So that, again, is twofold. So that's public legal education, where we are looking to raise awareness within the public about their rights, but also delivering seminars and training to build capacity within the legal sector, and that's not specific to just our areas of law.
In terms of the purpose and the aims of the organisation, is there a way that you can summarise that?
Certainly. The main purpose of the organisation is to ensure that we can raise awareness of rights and protect the rights of people that are experiencing disadvantage. So addressing inequality, addressing the impact of poverty, of deprivation. So a large proportion of the clients that we represent are people who've had complex needs, may not necessarily be able to understand and navigate the legal system in terms of being able to protect their rights. So we focus on protecting and advancing their rights through the influencing work that I talked about.
Is your organisation Scotland-wide? What areas do you cover and where do you have offices?
Our main head office is based in Glasgow, and we've got an office in Inverclyde. The majority of the work is undertaken within the Central Belt. We have some projects that are national-wide, so we've got a project that specifically focuses on employment advice, and that's nationally delivered. We've also got a project that focuses on improving access to justice for disabled people, and that is national as well. So largely it depends on what we have funding for. That sort of governs whether it is specific to a particular local area, a local authority, or whether it's national.
You mentioned funding there. How are these projects and how is the organisation generally funded?
A combination of different funding routes. So we get funding from Glasgow City Council and Inverclyde Council, and that's specifically to provide advice and representation to people in Glasgow and Inverclyde. We have funding through some Scottish Government streams, so we get funding under the Scottish Government Homeless Prevention Fund and the Scottish Government Equality and Human Rights Fund. And we have funding from independent trusts and foundations as well.
In your statement, I think you tell us that there is at least a proportion of your funding which also comes from fee income. Is that right?
That's correct. So that would be largely from legal aid work and or some private fee work, and our seminar department also generates some income from webinars and training events that we hold.
I think the proportion, at paragraph 11 of your statement, the proportion you tell us there is around 58% of the organisation is funded by grant funding and 42% of is funded by fee income. Would that generally sound about right?
Yes.
I wonder if I could ask you next, really, and I think you've explained that the purpose of the organisation is in terms of providing advice and representation at times for groups who find that difficult to come by and to access. What then does that lead into different sectors of the population which form your usual client base? And Alistair and Aileen, feel free also to answer this question in terms of your client base.
So based on where most of our project delivery is, so for example Glasgow and or Inverclyde, there's a large proportion of clients within those areas that live on low income, so are understandably impacted by poverty. A lot of our clients have multiple support needs, so I'd say a number of protected characteristics. So intersectionality plays more onto the circumstances that they may be facing in terms of the challenges that they have, whether that be in terms of housing or whether that be in terms of employment rights or any others. So we work with a lot of community organisations to ensure that people are able to access our advice and know where to go for advice. So a lot of our focus, whilst we have a lot of people that come to us in a crisis situation, we work really hard to try and do preventative work, so early intervention, but that does mean that we need to engage with a lot of grassroots community groups, a lot of other voluntary sector organisations, as well as statutory services. So as we were going into the pandemic, that was quite crucial for us, that people still knew how to contact us and get advice from us.
Alistair and Aileen, is there anything you want to add to that?
No, I think that sums it up very well.
You mentioned they're working with other organisations. Does your organisation also signpost clients or potential clients to organisations or support services that can assist them?
Very much so. That's a large part of what we do. Understandably, when we are trying to get to the root cause of why people have found themselves in difficult circumstances, you undoubtedly find out that they've got other support needs, and that's where the network of other organisations is quite crucial, so that we can signpost them, and or depending on what working relationships we have, we might be able to make what I would term as a warm referral. That's making a referral directly to the organisation.
You also mentioned there being potentially a difficulty, which we'll come on to discuss, about clients accessing or knowing where to go to access the service during the pandemic. But prior to that, how did clients typically access the services?
So prior to the pandemic, it was largely a face-to-face service. We had drop-in clinics on a weekly basis, so 3 or 4 days of the week we had drop-in clinics, so somebody could just simply walk into the office and wait to be seen by a solicitor. And as we obviously moved into the pandemic, that face-to-face service delivery and that drop-in clinic had to change dramatically.
In terms, I think, of both your statement, Aaliyah, and Alistair's statement, you both discuss the running of a help desk in Glasgow Sheriff Court. Can you tell me a little bit more about that?
Yes, certainly. So we provide an emergency legal help desk at Glasgow Sheriff Court. That is for people that are facing court proceedings and have not previously sought legal advice. So our team are able to get instructions from them on the day and represent them at the hearing. And that service, I would say, is very crucial, in the sense that if people don't get that legal advice and they don't know how to navigate the court system, undoubtedly the results could be that they could be facing eviction proceedings.
Moving to discuss the immediate impact of restrictions and the national lockdown on operations, and thinking back to March of 2020, when all of that was put into place, what immediate steps did the organisation require to take as a result of that?
So like I explained, we largely were a face-to-face service delivery, and the nature of our clients developing that trust and rapport is quite crucial. So the first thing we needed to consider was, how do we change from a face-to-face delivery to online mediums? Also being very mindful of the fact that not all of our clients would have had the digital means to be able to contact us. But we did implement systems to ensure that we were accessible. So our telephone line, we had a 0800 number, so that cost implications were not a barrier to people getting through to us. But at the same time, we needed to ensure that the infrastructure that we had could support that. So at the time, we had an analogue telephone system. So we needed to figure out, how do we actually move to digital means? How do we ensure that people are able to answer phones at home? And at the time, trying to be able to get IT support to be able to put that into place was extremely challenging. We had, through sheer coincidence, early in the year, looked to replace some of our computers that were becoming obsolete due to an upgrade in Windows. So had invested in some laptops and had considered moving to Office 365 that provided more sort of digital abilities, but we didn't have the IT backup to be able to implement that, and it was a lot of learning on your feet and a lot of consulting guidance and being able to test whether the system was working. So yeah. A lot of challenges to overcome, but we were really pleased to be able to turn what was a face-to-face delivery to online mediums. So the infrastructure was one side of it, but then making sure that people knew that we were up and running was the other side of it. So that was engaging with our partners to ensure that they were aware that we were functional, and also Glasgow City Council had various platforms where you could go in and update your entry details to say what you were doing and how you were doing it. So we made sure that we updated all the various places of information that we were aware of at the time.
There's a part of your statement, I think at paragraph 70, where you discuss even before lockdown was announced and even before restrictions were put into place, you wrote to the Sheriff Principal at Glasgow Sheriff Court to raise concerns in relation to the situation. Can you tell us a bit more about that?
Yeah, so on a weekly basis we provide the emergency help desk provision at Glasgow Sheriff Court. So up until the week before we went into lockdown, as far as we were aware, cases were continuing to be held at Glasgow Sheriff Court. On a weekly basis, we already know of cases that we've already had instructions for and required to appear for, other than the people that instruct us on the day. So from my memory, I think we had about 16, 17 cases that were already listed, and a total of about 100 that were on the roll. So we wrote to the Sheriff Principal highlighting the concerns that we had for our staff to be attending in light of what was emerging in terms of the risk and what measures the court were going to be taking to ensure that our staff were safe to attend, and or I recall we suggested that perhaps the cases should be assisted in the short term until there was a bit more clarity on what was going to happen. But from, I suppose, an operational point of view, it was really concerning for me that until and unless we knew otherwise, that I could potentially be asking staff to go into a setting where it was perhaps not safe for them to do so. You can well imagine from the numbers that I've highlighted that it wasn't going to be a quiet court call.
And I think you tell us at another part in your statement there are around 32 members of staff, is that right?
That's correct.
Picking up on that immediate or what happened as a result of the restrictions being announced, I wonder, Alistair and Aileen, if you can tell us about the immediate impact in terms of litigation work in general. What happened to the cases that were currently on your books?
Well, by and large, they ground to a halt. A decision was taken to discharge or adjourn any outstanding hearings, and matters by and large were assisted. I think it was only around the summertime when cases began to restart, probably June or around June 2020.
In terms of the Mental Health Tribunal, they did move over quite quickly to teleconference hearings. I think it was maybe within kind of 7 to 14 days, but it was obviously a system that people were not used to using, and it was a lot of changes, especially for those clients who were detained in hospitals.
Aaliyah, you'd spoken previously about fee income being a proportion over 40% of your income. What impact did the reduction in litigation have on the LSA financially?
Okay. So a lot of the work that we do that's under legal aid work, it is the litigation side of the work that we get more income for. And when there were no cases that were proceeding, then that obviously had an impact in terms of a reduction in our legal aid income.
Were there any mitigations put in place in relation to that?
The Scottish Government did have the Legal Aid Resilience Fund, so we were able to apply for that. We were one of the few law centres that were able to apply for it. The criteria, from my memory, depended on the percentage of legal aid income that constituted your overall income for the prior year. And we hold the secretariat role for the Scottish Association of Law Centres. So that's all law centres that meet on a monthly basis. And we did engage with the Scottish Government to highlight the limitations within that criteria for everybody to be able to apply and get funding through that grant.
You tell us within your statement, I think beginning at paragraph 37, about the various grants which were made available to you as an organisation throughout the pandemic, and there seem to be a number of them. I wonder how easy or difficult was that process for the organisation on top of all of the other changes that you've narrated you had to make?
Firstly, I'd like to acknowledge the fact that those grants were available because they did allow organisations like ourselves to be able to meet costs that were unexpected. But each of those funds, you actively had to look to see what funding was available, what the criteria was, whether you were eligible to apply or not, and then obviously to submit the application in a very short time period. And that was on top of everything else that you were already dealing with, a lot of what took longer to do. So there were a lot of administrative things that fall upon you that you weren't necessarily doing previously. So I was responsible for submitting the funding applications and then submitting reports and keeping my eye on what funding opportunities were available. And it wasn't that they were listed in any one central source, so you were sort of undertaking research of various different source points to see what funding you could apply for and then submit the application. So whilst I was very grateful, obviously it came with a lot of additional work on top of what you were already doing and then the changes that you were dealing with.
I think as part of your role, you tell us within your statement at paragraph 15 that you also at that time were having to communicate with staff and members to provide them with updates and provide them with guidance about how the service was going to run, or the changes that needed to be made in line with the updates to the restrictions. I wonder again if you can tell us more about that process and how either easy or difficult it was in order to collate that information and disseminate it amongst your staff.
Yeah, certainly. So I think first and foremost, you needed to consult the Scottish Government and or the NHS guidance in terms of what changes were happening. And we created almost two different ways of communicating with staff. We used our Teams channel as one of the main sort of day-to-day communication, but we also had an overarching document that we had prepared, which was almost like a risk assessment of, if this is the issue, what are the mitigating actions and what you need to do. Preparing that as a scratch was a lot of hard work, but then you needed to constantly make sure that you were updating it as the guidance was being updated, and make it as easy as possible for people not to have to go through the various loops is probably not the right word, but you sort of like were consulting one website to the next, so you wanted to sort of consolidate all of that time and put that into a central document for staff, which we did. But you obviously almost had to update it on a regular basis to see what's the guidance now. And I appreciate it was a changing landscape for everybody. But a reflection would be how to make that easier for people to understand what exactly has changed, so that it's easier for you to digest it and undertake next steps that you need to.
And Alistair and Aileen, you're obviously trying at least to carry out your role in whatever changing way is happening at the time. How easy was it for you to receive that information and take action on it while also making sure that the normal work was being done?
I think in terms of our internal processes, it worked okay. We did the best that we could. We maintained our services. We maintained access to office or physical files when needed. And I think all staff at all times had a fairly clear idea of what could and couldn't be done. There were obviously practical challenges in terms of engagement with clients, and straightforward things such as having a meeting just wasn't really possible for the first 3 months. But given that we had the remote IT systems, telephony and everything set up to go fairly quickly, we were able to pretty much operate at normal capacity throughout.
At the beginning of the pandemic, I was not part of LSA, so I can't really comment, obviously, on the procedures that Alia and Alistair have spoken about that were implemented within the organisation. But certainly with the firm that I was working with at the time, again, fortunately we had laptops set up, and there was the remote means of communication between my employer and fellow employees. But just as Alistair has kind of said, the main difficulty was, I suppose, contact with clients and just not having those meetings which we were used to have.
I think you tell us in your statement that generally pre-pandemic meetings with clients who were in the mental health tribunal proceedings took place face-to-face, sometimes in hospitals and restricted settings. And you tell us that those face-to-face meetings simply stopped, they were no longer permitted. How did you deal with that, and what did you manage to find a way around that?
I suppose it varied from, client to client. As you said, yes, when clients are detained in mental health hospitals, we would go out and we would be visiting them on the ward face to face. We then had to change to telephone contact, which was quite challenging at times. First of all, not all clients had access to mobile phones, depending on the types of ward that they were admitted to. We were then perhaps relying on ward phones, but then you might have had 20 odd patients all looking to use the one phone. If they did have mobile phones, some of the wards, they had little to no mobile phone reception. You also had the challenges as well that because of some of the clients' mental health diagnosis, they maybe had kind of paranoid beliefs about using technology. You were simply just a voice at the end of a phone, particularly if it was a new client. So there was that added difficulty of building up trust and rapport with clients. So that was, every client you had to take as they came and try and kind of work out a way in which to best communicate with them so that we could continue to try and provide them with the advice and the support that they needed.
You mentioned an important element, particularly in your field, for the solicitor-client relationship as trust. Would that have impacted on your ability to build relationships with new clients? Personally, I believe that it did. During the pandemic, there were quite a number of people who maybe found themselves subject to detention under the Mental Health Act, which perhaps never had any involvement with mental health services before. So they were subject to a completely new environment, didn't know their legal rights, maybe perhaps had never engaged with a solicitor before, and then all of a sudden you're on the phone telling them, well, we can try and help you, but they don't really know who you are. They can't put a face to that voice, and I do feel that it did impact on the solicitor-client relationship and having that element of trust. In terms of being able to put a face to the voice, was there a slower introduction of video calls, or were they just never introduced and it typically was telephone calls? It was typically telephone calls. I can honestly say that there was a number of clients I represented during the pandemic which I never had physical sight of, because meetings were over the telephone and then tribunals were conducted by teleconference as well. In your statement, I think at paragraph 19, you say quite pertinently that you are sure there are people who didn't exercise their rights to legal representation because they felt at that time that they couldn't access any services.
Yes, well, whilst I don't have any, I suppose, numbers to put forward in terms of that, just in terms of my experience of being a solicitor in this particular area of law, I do feel that there would be individuals who didn't exercise their rights for a number of reasons, whether it was lack of technology to allow them to do so, lack of information as to their legal rights, and just an unawareness of that they did have access to a solicitor. When clients are detained in mental health wards, as well as having the right to legal advice, they also do have right to an advocacy worker who's there to, I suppose, support them, help them put their views through. But an advocacy worker is an important link because they will also, discuss with them. There are solicitors who can help you and will present them with a list of solicitors. But those advocacy workers were obviously prevented from accessing the mental health wards as well. So there was that, I suppose, that link wasn't there, and in particular for people who were new to detention under the Mental Health Act, I just feel that they didn't know what their rights were.
Alistair, of course, a different client base and perhaps a different set of circumstances insofar as your clients won't necessarily be detained in hospitals and the like, but I wonder if any of those issues also strike a chord with things that you experienced during the pandemic.
I think there probably was a group of people who didn't exercise rights that they would have otherwise. Perhaps due to the Sheriff Courts originally moved to telephone-based hearings from in-person courts for eviction cases, and parties, if they wished to attend a telephone hearing, had to provide by email a telephone contact number by a certain date in advance of the calling date, and for a group of people that sometimes would struggle to attend simply with a court date and a time, I could see that it would be one step too many for them to follow those instructions, notwithstanding that it also removed the physical face-to-face assistance that we were able to provide to those when they did attend court prior to the pandemic.
And of course there was that service available to people who were turning up to court who didn't have representation insofar as the help desk at Glasgow Sheriff Court. What impact did that have, the fact that there wasn't a physical help desk, there wasn't somewhere physically to go to seek representation?
There wasn't an ability to run a help desk. We moved from, when I say a help desk, I literally mean a desk placed outside the relevant court with a sign on it regarding advice and representation, which all party litigants can attend on the day of the hearings. That changed to a remote telephone hearings with sheriffs calling participants one by one. So it simply wasn't. There was no ability to even contact party litigants to manage to obtain representation, because we simply didn't know who they were or how to get in touch with them.
Were there any avenues open to those people? Did the organisation go to any different lengths in order to try and make those people aware that there was a service that they could access if they were able to?
Well, there was, certainly in relation to our work in Glasgow, there is some data sharing agreements in place where we can at least we make an effort to make contact with any parties whom Glasgow City Council have been notified that they are at risk of losing their home, be it through eviction, repossession proceedings. We will contact them in writing to try and make them aware that there are sources of advice available. Even prior to the pandemic, though, that has a very low take-up rate, and that certainly didn't improve at all during COVID.
what you're describing there, was general line questioning possibly applies to Ms Miller as well, but from what you're just telling me there, there was a system whereby, prior to the pandemic, you could act proactively. You could make the effort to contact someone that was at risk of losing their home.
Yes.
That presumably continued to run after the pandemic started.
Yes.
But I would suspect, and I think you've probably inferred it in your answers so far, that many of the sort of people that might benefit from that service may not have access to computers.
No.
Possibly not even access to mobile phones or anything like that.
Sometimes, more often than not, they would have access to mobile phones, but whether or not it had the necessary data packages to communicate by email, etc.
Yeah, well, I was getting to that point,
Yes.
yeah. Because I think you said earlier on that if you wanted to participate with the court process, the person had to send in advance a telephone number. And to do that by email, you've got to have some means of sending an email.
Yes.
So it does appear to me that it's quite a serious issue, that there are people who, through no fault of their own, could very easily slip, and it applies to the mental health issue, I think possibly even more potently, could slip through the net.
Yes.
A question you quite possibly can't answer, Mr. Houston, but you had this ability to, by means of communication or a system you had with Glasgow District Council, communicate proactively with people. Did that sort of system exist throughout the rest of Scotland, do you know, with local authorities?
Not unless local authorities had put it in place with any other third sector organisations. If there are organisations operating, they may or may not have such an agreement. But
I suppose I am not criticising you. You're obviously telling me the truth, but I suppose the strict answer is you don't really know.
yes.
It does seem to me that there's a wee bit of a hole in the system in relation to that, in the circumstances of a pandemic in particular.
Yeah, and I think even more so that certainly from the client group that I'm used to working with, they are a group of people that unfortunately will perhaps not engage until the last possible moment. And when things are being done remotely, that last moment sometimes seems further off to them, and there perhaps isn't the...
Chimes with other evidence we've heard in the same sort of sphere. Yeah, I'm sorry to have interrupted.
No, of course not.
Yeah, thank you.
In terms of your reference to that last moment perhaps seeming a bit further off, you told us earlier, I think, that at the commencement of the pandemic quite a number of proceedings were assisted. And you tell us within your statement that there was an adjournment of eviction proceedings generally, at least at the start. In your view, was that helpful, and what impact did that have on the client base?
It was helpful in the short term. It's very rarely to a defender's benefit if eviction proceedings are litigated to a conclusion, absent an extrajudicial settlement of some kind. So it certainly removed the immediate pressure. However, when things began to restart and get moving again, you found that perhaps you'd lost contact with some of the client group, the engagement had dropped off. But certainly in the short term, it was probably to their benefit.
In a circumstance where your client has been able to, say, join a remote hearing either by joining a telephone conference call or by accessing a link to join a video hearing, how were they able to participate in those proceedings, and in what aspects was that either made more easy or difficult because of those remote means?
I did not have a client attend a hearing with me remotely until 2024. No, I just did not have any telephone hearings or WebEx video hearings that went ahead with clients present. And there were actually, with regards to the telephone hearings that were occurring in the earlier part of the pandemic, my understanding was because that was not possible. that a telephone number could be provided for a party or their representative, but it simply wasn't possible to have both attend.
I think you tell us at paragraph 25 of your statement there were instances you experienced where adverse decisions were made against tenants at telephone hearings where that person wasn't present, and that being a particular difficulty.
Yes. Historically, particularly with cases where you're perhaps taking instructions fairly late on, it's always helpful to have a client in the court with you. But you were left with some hearings where there wasn't the ability to simply ask a client to fill in the gaps in your information, and it led to orders being granted which would see them lose their homes.
Aileen, you also discuss within your statement the participation of clients in hearings which were conducted online and I also think by teleconference. Again, how did you feel that clients were impacted and able to participate in those proceedings compared to how things were previously conducted?
So pre-pandemic, all hearings before the Mental Health Tribunal for Scotland were held in person. The set-up of the Mental Health Tribunal is it's a panel of 3 people, so you have a legal member, a general member and a medical member. And then, I suppose, on the opposite side of the table, you would have the patient concerned, their solicitor, if they had an advocacy worker, you'd have their psychiatrist, and you'd have a mental health officer who is a representative who works for the local authority, and sometimes there may be family members of the patient. So really all those people would be sitting around a table in person. During the pandemic, as I say, they did transfer to teleconference hearings. Video conference hearings were few and far between, so I would say the majority of the hearings were teleconference. Alistair obviously said that his court hearings there wasn't the ability for representative and client to phone in. The tribunal service they set up teleconference hearings using the BT teleconference line, so it meant that all parties were able to dial in on a secure line. But you then had, say, 7-8 people on a telephone call, so people that you've never met before, and particularly for the client, they've got people making decisions about their freedom because they're detained in hospital. So clients did have that ability to participate, but again, it was whether or not they could participate due to the lack of technology on the ward. Again, the teleconference line, it was an 0800 number, so if they were using their own mobile phones, there was no charge to them. But as I said earlier, not all clients would have access to their mobile phones or their reception issues, and then you were relying on ward landlines to be made available. Some clients chose not to participate because they didn't want to, because they felt it might be too confusing on the phone, hearing different voices when they couldn't actually physically see the people that they were speaking to. Sometimes, again, due to their mental health diagnosis, there was that element of mistrust because, again, they didn't know who it was they were speaking to. There was also the difficulty as well that whereas you're face-to-face, you have the social cues from individuals about when to come in, answer questions. That obviously wasn't there over a telephone line, so sometimes it did get quite confusing as to who was speaking, when they were speaking, and even sometimes we had interpreters on the telephone as well, which obviously made things slightly more difficult as well.
I'm sorry.
Of course.
Mm-hmm. Dr. King, can I go back to Mr. Houston? I've been pondering what you said. I want to be clear. You were aware of situations, and we are talking about Glasgow Sheriff Court, I think. Yeah, where you were aware of situations where you had a client, who, and I think we're talking about evictions, but was threatened with eviction from their home. And because of the system that you described, there was only the possibility of either you or the client being in direct communication with the court process as it went on, the hearing.
That was my understanding, that for these procedural hearings you could only
And I think from what you've said, there were occasions when you were the person that was on the telephone call and not the client.
Yes.
And therefore, in a practical sense, your client was deprived of the right to be present at a court hearing pertaining to some important aspect of his rights.
Yes.
Strikes me as a breach of natural justice.
Potentially, yes.
Yeah. Were you ever in a situation where you asked for, in those circumstances, an adjournment and it was refused? I suppose ask for an adjournment's the better question. Forget the refusal part.
Yes, from memory, there would have been occasions when adjournments or continuations would have been sought. I think by and large they were most likely granted, but I do have recollection of one particular incident where a defender that I personally was representing had an order granted against him which saw the loss of his home, and he had not been able to join the hearing, and he was very clear that he would have preferred to have been present.
Yeah, well, thank you. I'm sorry to have to go back to that, but it does seem to be pretty stark and something that a person shouldn't be deprived of, a right which exists to attend at a court process affecting their rights.
Yes, I agree.
Yeah, thank you.
Aileen, I think you were talking more about that right being offered to people who are subject to mental health tribunal proceedings, but those people, for whatever reason, and there being various reasons, not feeling able to participate rather than them being excluded from participation. Is that right?
Okay.
I suppose that could still be a deprivation of right.
Of course.
I think in terms of being excluded, that sometimes they were excluded because of the lack of technological means as well. From memory, I can recall a few tribunals whereby we tried to hear from the patient, but the reception was just so terrible. You were getting sort of every second word from their evidence, and we tried numerous times to get a better connection, have the patient moved to another part of the ward to see if the reception was better, but ultimately we had to just continue with the hearing.
Just continue or discontinue? We
continued in the patient's absence. And
that's not satisfactory either, is it?
It wasn't ideal, but some of these hearings they are time sensitive. So in terms of the legislation, they have to be heard within a certain period of time. So you didn't always have the option to seek an adjournment or for matters to be continued to another day. Even if they were continued to another day, you're still going to come up against the same issue if it comes down to lack of mobile phone reception or lack of them being able to communicate on the phone.
In a circumstance where the reception or the access to the technology to enable them to join hearings was an issue, was it raised with wherever they were, and were there attempts made to correct that?
Yeah, so it was raised. I suppose it was raised in different forums. In terms of sometimes the legal convener of the tribunal would say, is there anything we can do? Prior to hearings taking place, I would normally phone the ward to say, this person has a hearing at this time. Can you make sure, there's a quiet room available for them? Can you make sure there's a phone that's working? But unfortunately, it didn't always work out.
You talk in your statement, I think, about there being almost a disproportionate impact on those who are in state psychiatric hospitals. Can you explain more about that?
Mm-hmm. So the state hospital is the sort of the high security hospital for people who are detained under various types of orders. In terms of contacting patients, first of all, you have to be screened by state hospital security, so you have to be added onto an approved list of that particular patient. Then in contacting the client, you have to phone the ward, leave a message, and then basically your contact details are screened against the security list for them to be able to return the call to speak with you. That's always been the case, I say, pre-pandemic and now. They obviously don't have, there were no, I suppose there were no changes to make contact easier with those clients during the pandemic. You still had to go through the same process. And again, in terms of the tribunal hearings, the State Hospital did have a WebEx suite set up so that they could participate in by video conference. But 9 times out of 10, there were errors and the system failed, and then we had to just resort to teleconferencing for the tribunals.
And again, within the statement, and I think you've already made reference to it, but you consider there to have been a disproportionate impact also on people who English wasn't their first language, and they had to participate with the added requirement of an interpreter in those proceedings.
Correct. Even to have sort of initial, I suppose, those individuals making initial contact with a solicitor if they were detained, they didn't always have the means to do that if English was not their first language. And then if we were representing them, again, it was by telephone appointments, but then you were having to set up conference calls with the client and also an interpreter and yourself. Sometimes there might be an advocacy support worker there as well. And then if it came to the tribunal, again, we had obviously the added complication of an interpreter being on the line and having to go through that process.
And the interpretation was happening live on the line while everybody else was also...
Yes.
It seems like an obvious question, but did that have an implication in terms of the time that hearings were taken?
Yeah, quite significantly. Majority of mental health tribunals, you're maybe looking at kind of maybe taking about an hour and a half. With interpreters, sometimes we're going on for 3.5 hours. There were kind of additional breaks that were required to allow people, I suppose, just to kind of take a breather, let the interpreter sort of reset as well, and then dial back in. So when you have face-to-face tribunals, the interpreter is generally sitting next to the patient and just interpreting, as things go on. But with the teleconference, it was obviously one person would speak, interpreting one speak. That and following that process, so it did significantly add on to the tribunal court time.
In terms of the way that you were able to conduct your role, representing clients' interest in these hearings, how did all of those things impact on the way that you felt you were able to do your job?
I do think it had a negative impact on the way that I was able to, I suppose, effectively, represent those clients. In terms of, yes, we had the internal infrastructure, to allow us to work remotely, but I feel that the limitations on being able to kind of contact those patients, and sometimes you were perhaps even hurried up off the phone if it was a word phone because there was another patient waiting to use it. So I felt that sometimes you were still giving them the advice, but perhaps you were not exploring things in as much detail as you would have done if you were meeting with them face to face and you had that, I suppose, unlimited time to sit and go through things with them pre-pandemic.
You spoke previously, I think, about how trust is extraordinarily important in these cases. Were there times where you felt you weren't able to get information from the clients because they didn't feel they had that relationship with you?
Yes, and sometimes as well clients would just say, well, I don't want to talk about that over the phone. If I see you, I'll tell you. But there wasn't obviously that opportunity to do that.
Alistair, a similar question for you. How do you think all of these restrictions and changes to the way that you work affect the way that you were able to represent the clients?
I think broadly we were still able to represent them, but I always think that communication is always easier both with a client face-to-face and with a court or tribunal face-to-face. It's easier to listen to what someone is saying to you when they are in front of you, be that, like I say, a client or a decision maker. So I'd like to think that in terms of the quality of legal advice, that was still there. In terms of the representation, it maybe suffered somewhat. It still existed, but it's always easier to be in front of someone as opposed to on the end of a telephone. Communication-wise with clients, we perhaps didn't have quite the same levels of difficulties as Aileen did with her clients, but I do recognise that answer of a client gives to not wanting to discuss something over the telephone, that they do feel more comfortable face-to-face in person.
Within your statement, I think you also talk about the difficulties you experienced in trying to get information from third parties that you work with fairly frequently, people like the Scottish Legal Aid Board and the Scottish Court Service being quite difficult to contact.
Yes, it did become more difficult to get somebody on the end of a telephone at the start of the pandemic, whereas before it was relatively easy. The Civil Clerk's office in Glasgow was particularly difficult at the start of the pandemic to speak to.
How did that affect what you were trying to achieve?
Most communication had to go through writing, and to be fair, dedicated email addresses were set up for different types of cases, and I'm aware that while some of the smaller courts were being funneled through hub courts, just the mode of communication needed to change. Whereas once you could pick up a phone, find out some information about a case for a client, it just seemed that it wasn't that sort of instantaneous source wasn't there anymore.
Aaliyah, I think it's in your statement at paragraph 48 that you talk about there, in some instances, being an expectation on the Legal Services Agency to facilitate clients joining online hearings, participating in all of those things. And I wondered if you could tell us more about that expectation and how you felt about that as an organisation.
Yes, certainly. So we had an instance where we were expected to arrange for the digital access for the client to be able to participate in the hearing, and this was during the point of coming out of lockdown, where we hadn't fully opened the office to face-to-face appointments, bearing in mind that different staff members had different circumstances at home in terms of vulnerability, shielding family members, etc., etc. And as far as I'm concerned, our responsibility was to ensure that we could effectively represent the client, effectively represent their interests, but going above and beyond to ensure that they had access to digital means, I felt was not our responsibility, but we were left in a position where we had to consider how that client might come into the office, what room in the office might we be able to facilitate for them to be able to use, to be able to participate in that hearing. And that caused a lot of concern for us in terms of ensuring that there wasn't a detrimental impact for the client, but also the different levels of comfort within the staff themselves of having somebody come into the office and the various checks and balances that needed to be in place. So that I felt was not our responsibility. to arrange that. And I think just to a couple of points that Aileen and Alistair have made, we talk about the difficulty in being able to speak to somebody, and we've also talked about the people that we are concerned about that maybe weren't able to get advice, and for that access to various services to only be by written means through email communication, where somebody might not have access to digital means to do so, may not have the ability to be able to send an email, the lack of being able to pick up the phone and speak to a human, I think was something that did impact not only us, who were able to navigate other sources, but actually people who may not have any other means. So I think that was also something in terms of a reflection of what might we do should we find ourselves in this situation again, to be done differently. So whether it's local authorities, whether it was the various mediums that Alistair's already mentioned.
You've obviously all given examples and told us how there were quite significant challenges during that time. Aaliyah, did the organisation see an impact on staff because of the circumstances, the challenging circumstances that everybody was working in?
Definitely. I think I really have to commend the staff for their determination and their compassion to be able to support clients, but you were effectively in your own home dealing with fairly difficult circumstances. You didn't really have the ability to be able to switch off. Sometimes people were very frustrated and you were at the receiving end of that frustration, albeit the frustration wasn't directed at you, but you were receiving that frustration. You weren't in an environment where you might be able to turn to your colleague and just share what you had experienced. So I think it did impact people being able to switch off and people not being able to share with colleagues what might have been a really challenging conversation. So I think it did impact on well-being. We did try to mitigate that in terms of having online sessions just for our team ourselves, in terms of vicarious trauma or dealing with people that might be experiencing anxious circumstances or be experiencing anxiety. But undoubtedly, the work that we were doing and the kind of work that we were doing did have an impact on our staff.
I think all of you individually, or perhaps Aaliyah and Aileen, discuss in your statement the categorisation of staff as key workers and the fact that nobody at LSA, I think, was categorised as a key worker. Do you think that that would have assisted in terms of the organisation generally and you individually as to how you might have been able to conduct your work during that time?
I think it would have had significant impact. So for all intents and purposes, with the limitations that were there, we were functioning and did so from day one of the pandemic. We continued to receive posts, we continued to advise clients, we continued to send posts. We didn't have any, we weren't classified as key workers, so all of the staff had been issued letters to confirm why they were perhaps out of the office, out of their homes. We also had staff who were parents and were looking after children and helping in terms of school and so on and so forth, which they didn't have the provision to be able to have their children go to school. And we certainly didn't have any immediate access through key workers to any vaccines at the point that they were available.
Aileen, I think in your statement you mentioned as well key worker status and that potentially, if that had been granted, having implications in terms of being able to visit care facilities or hospitals.
Yeah, so some hospitals and care facilities, they were still obviously allowing doctors in, representatives from social work, etc. But as legal representatives, that wasn't that wasn't allowed. So I think if we did have that key worker status, then it could have made, I'm not saying for all cases, but certainly cases whereby digital communication wasn't an option, would have given us that option to have that face-to-face contact. In addition to that, when sort of restrictions began to lift slightly and we were allowed to access hospitals again, because we weren't regarded as key workers, we had to source our own COVID tests, and you know, sometimes we might have been in two hospitals a day, so you know, from a personal point of view, you were having to go and source those COVID tests, which weren't always readily available. I think Alia might be able to touch, but I think we did try to access through as an organisation, but I don't think they were forthcoming.
Alia?
So there was a provision for you to be able to apply for COVID tests to be delivered to the organisation. The process itself was not straightforward. It used a system called egress, and I was familiar with it, having used it in a different capacity. We managed to navigate through that, but we didn't have anything in terms of any delivery, so we continued to ask staff to source their own COVID tests.
I think egress might typically be the platform used by local authorities rather than just general third sector organisations, is that right?
I know of it as a secure system through some committee work I do through the Law Society of Scotland. But why, once you navigated through the system, that actually you didn't have any deliveries and there wasn't anywhere that you could just pick up the phone and say what is happening. So I think sort of going back to means of communication and how effective that is, the fact that you couldn't speak to people had sort of multiple barriers in different settings, and this being an example.
Aileen, you are in the interesting position of having changed jobs, having joined the organisation during the pandemic, and I wondered if you might be able to give us an insight as to what your experience was like in being recruited and trained and being introduced to an entirely new workplace whilst all of this was going on.
So I suppose the first point being interviewed for the new role. So instead of actually physically going to your potential new workplace to be interviewed and meet people face to face, it was a panel interview over Microsoft Teams. So that was with Alia and two other colleagues. I suppose that in itself was quite a strange situation to find yourself in, meeting people for the first time, but also the added, I suppose, pressure that this is a job that you're wanting. So I suppose that was the first thing. When I joined LSA, I was doing the same area of law. So, but there was the I suppose obstacles of it was a new case management system which I had never used before. Just generally meeting colleagues, new office procedures being in place. When I had started at LSA, restrictions had lifted slightly, so there was a rota in place that people were in the office on certain days to minimise the number of people who were in at any one time. So I was able to meet some of my colleagues, but as Ali had said, some colleagues, were working from home more due to their own kind of vulnerabilities or family circumstances. So there was actually one colleague that I've never met for 2 years, due to obviously the restrictions in place and I suppose things coming back to normal.
Do you think because of the area that you work in, and perhaps the cases being somewhat sensitive and quite complex, and the clients being having particular challenges in terms of communication, that lack of a collegiate atmosphere within the office impacted upon your ability to take on the new role and the new cases?
I don't think it did. As I say, I was coming from a job whereby I was already dealing with those types of clients, that type of work. I was used to dealing with navigating the tribunal teleconference system and the restrictions in place. LSA did have a good internal setup, so we had Microsoft Teams, so albeit there were perhaps members of my department that I hadn't physically met, we would have weekly team meetings whereby there were video conferencing, so we were actually able to see each other. If there were any issues with kind of admin systems, anything like that, members of staff were only kind of a message away, so I don't think it had any great impact.
I wanted to ask, in terms of longer term impacts, about to do with all of the things that you've mentioned. So the telephone hearings, sometimes there being WebEx hearings, there being an adjournment of eviction cases for a postponed period. Can each of you, I wonder, tell me any long-term impacts that those things have had, perhaps things that you're still seeing now or were seeing in the years following the pandemic?
I'll have a start at answering that. So a large part of my role is reporting not only to our funders but also to our boards. So undertaking a bit of a trends analysis and understanding what we're doing, what is it telling us, forms part of those reporting. And certainly in terms of the eviction work, what we are seeing is people have really high arrears, higher than what we've seen pre-pandemic. And for people to be able to clear those arrears and have legal advice in those circumstances, I think, is even more crucial. Excuse me. And the reason I say that is that obviously the higher the arrears are, in terms of putting forward a defence, in terms of ensuring that you're working towards clearing them, not only do you need that legal advice, but you also need, I spoke about earlier, the network of other organisations that we work with. So you actually do need a system that supports that individual. So we're certainly noticing a higher number of cases, relatively higher number of arrears, whether you look at the lowest or the highest. They're in the region of 4,000 going up to above 8,000, whereas pre-pandemic, perhaps 2 was what we might have seen. So a significant difference in arrears having built up over the pandemic. The other observation I have is that there were some provisions that were introduced during the pandemic in terms of the Tenants' Hardship Fund. From my understanding of the various network meetings that I attended, there wasn't enough of an understanding within the public to be able to take up on those provisions. And I'm not sure whether the administration of it and or the criteria of it needed to be reviewed. And then the final observation I would make is where the government were introducing legislative changes and protections. Again, I think they needed a bit more consultation with frontline organisations to see whether they reflected the actual experience. So there were provisions that eviction proceedings would perhaps not be instigated if somebody had arrears of a certain amount. And I don't know the exact amount, but roughly it was about over 2,000. If on the ground rent arrears are much higher than that, then that's not necessarily going to make any kind of a difference. So if you were introducing certain protective measures, recognising the unusual circumstances that we'd all experienced, I think that engagement with frontline organisations to see what actually would have made a difference would have been more helpful than introducing something that was not necessarily achieving its objective. So those are sort of 3 very high-level observations I had in terms of certainly the eviction work. And I'll let Alistair add.
In terms of lasting effects, there are procedural courts in the Sheriff Court, but using Glasgow as an example, that are now conducted entirely by WebEx video conference. That includes the procedural courts dealing with the applications by heritable creditors. We used to run a help desk for homeowners and debtors that were perhaps facing repossession proceedings. That's never been able to be reinstigated because there's now this move to WebEx video conferencing in the first tier tribunal. Proceedings prior to the pandemic in the Housing and Property Chamber were entirely in person. Nowadays they are almost entirely remote, from case management discussions taking place almost entirely by telephone through to hearings that I think are, there's a presumption it'll either be by telephone or by WebEx as opposed to in person.
And I take it from the comments that you've expressed earlier, that it seems is more convenient for solicitors and the court service, and perhaps more efficient. Do you think it is more, the clients have proper access to justice using those means?
Well, I think there's the clear loss of emergency advice on the day to homeowners through in the Sheriff Court. There wasn't the same provision around tribunal proceedings, so that's not something that's been lost. But I think there's the same issue about decision makers having to make decisions about someone at the end of a telephone line and whether or not they lose their home, as opposed to seeing them face to face and hearing from their evidence in person. Certainly it's not my preferred mode of communication.
Aileen, similarly, have you noticed anything in terms of trends or lasting effects from the unusual years that you were working during?
I suppose in terms of lasting effects, although the Mental Health Tribunal have reverted to in-person hearings, there is still quite a substantial amount of them that do take place by teleconference. And I do feel that sometimes it is maybe depending on who's making an application to the tribunal. So, for example, if it was myself on behalf of a client, I would ask the client would they prefer an in-person or teleconference hearing and take their instructions. However, if it's perhaps another professional, such as a psychiatrist or a mental health officer being the one making an application, 9 times out of 10 they will put down their preference, which would be teleconference. I fully appreciate that they have competing needs of their time and other things to do, but I still feel that there is an unfairness there, that certain types of applications are heard by teleconference when in fact they should be by in-person hearings. In saying that, however, there are some hearings that do work better by teleconference. If they are just short procedural hearings, then of course it is a better use of, I suppose, all professionals' time, whereby the clients are not participating for a hearing that's only going to maybe take 10-15 minutes to be done by teleconference. I suppose there are pros and cons in terms of what we have experienced during the pandemic.
Alistair, I wondered, is there a similar provision or ability for you in terms of requesting an in-person hearing where you think that might be appropriate, and is it accommodated?
I think in terms of the procedural courts at Glasgow, there is an ability for a party to attend the court building if they cannot, if they don't have the sufficient technology to attend remotely. However, they do then attend the WebEx conference from within the court building. With regards to the first tier tribunal, my understanding is that there is provision to request different modes of hearing, but I have to be slightly careful, as I don't deal with any representation before the first tier tribunal, as I sit as a part-time legal member, so I have to be careful I don't conflate my experience with sitting as a legal member with acting as a representative. But I think if representatives can make and parties can make requests, and certainly if there was one party that expressed a preference for video conferencing, then the tribunal ought to canvass whether that is convenient for everyone.
You all very helpfully within each of your statements have given us some reflections in terms of lessons that you think can be learned from the experience that the organisation had. Alia, I think you particularly throughout your statement pick up on communication being an issue and being a relevant lesson, and I wondered what you think can be done to allow better communication both with the Scottish Government, local authorities, third sector organisations, relevant support services.
I think just for a start, I'd like to just reflect on a couple of comments that Aileen and Alistair have made. And if we're talking about, firstly, just hearings, an important point in terms of access to justice for individuals and the particular consequences and the nature of the work that we undertake of the outcome of that hearing, whether that is the provision of freedom, whether that is the loss of their home. I think it's absolutely crucial that people are able to participate in that in a means that is effective for them. And there was a period where hearings being online were almost the default position, and I think that cannot be the case. I think it needs to be what is in the best interest of the individual in terms of the means through which that hearing is conducted. I think we do definitely need to look at what were the silver linings and where there are procedural matters, and that's an effective use of time. That is the right thing to be able to learn from that. But certainly full evidential hearings, and I can certainly recall colleagues who had appeared in full evidential hearings before the tribunal in relation to private rented sector, where it was extremely difficult to have a full evidential hearing that lasted a number of hours over the phone. So I think in terms of access to justice, I would make that strong point that online by default is not going to be the appropriate means in terms of people being able to engage and have their rights protected. In terms of organisationally, it felt to me like being a fairly small organisation with not necessarily perhaps a dedicated IT team, in fact, no dedicated IT team, we were able to implement infrastructures that allowed us to ensure that people could pick up the phone and speak to us. Emails weren't the only way that people could get in touch with us, but we didn't find that with a lot of other places, whether it be local authority or the court system and or other sort of official sources that we needed to engage with. And there's no substitute to human contact when you are able to speak to somebody to clarify. I mentioned a lot about the various sources of information that we needed to consult to be able to ensure that our staff felt informed of what measures were being put in place in terms of their health and safety. And you did navigate through a lot of information. You tried your best to make sure that you understood it properly. But again, there was not that human contact in terms of any kind of a helpline that you could pick up to say, have I understood this correctly? Or I'm trying to source this. What's the best place to be able to do so? And I think if those means were there, they might have provided a bit more efficiency in terms of the steps that you needed to undertake to ensure that you were fully operational. I can remember many instances where the information that I had researched, I shared with other partner organisations to avoid them having to undertake that same research themselves. and or something that they may have mentioned that I was not aware of. So I think the level of communication could be improved, and means by which you can perhaps subscribe to certain things that are more relevant to the nature of your organisation without having to actively go and source it yourself, that something sort of maybe lands in your inbox and you've got the ability to be able to reflect and review what you do with it. Same's the case with the different guidance that was being issued in terms of if somebody did test positive, how many days they needed to isolate, so on and so forth. That was constantly changing, and if there was a way where that communication could have been more proactively received by people. And some people might not like it in their inbox, but having that option, I think, would have made a huge difference. I suppose my final reflection, we did make the impossible possible, and it shouldn't take a pandemic for that to happen. So I'd be really keen to understand how we take some of the learnings from this particular instance to future instances. And I'm slightly encouraged in that we perhaps maybe have already started to make that direction. We were speaking earlier that about a month back, where we were expecting a severe storm in the Central Belt, there was definitely better communication from various sources than I've seen before, whether it was schools being closed, whether it was the court putting up notices on their websites to say what hearings would go ahead and which ones wouldn't, that allowed us to then undertake measures to say, right, nobody's going into the office tomorrow. So I think we're making the right headway in terms of the recent reflection, but I'd like to understand what we're doing more of.
Alistair, reflections or lessons to be learned?
Not really too much to add to that, apart from to echo the issues with the communication. And we, as a fairly small third sector organisation, managed to get set up fairly quickly, learning the IT as we went, without any specialist departments or deep pockets in terms of upgrading what we already had. And it just seemed I was fairly disappointed personally from my experience with the public sector organisations and bodies I had to deal with, that it just seemed that they just weren't functioning as well. Whereas when you looked at other organisations in the third sector and in the private sector, they pivoted fairly quickly and were able to operate as best as they could, and that just didn't seem to happen in the public sector. Why that is, I don't know.
Again, I would completely agree with what both Alia and Alistair have said, but I think for me as well, it's just not to have that assumption that people are able to communicate using remote means or digital means. I think that assumption is quite detrimental, specifically to the types of clients that I represent. So I think sort of moving forward is perhaps to ensure that mental health wards, they've got adequate facilities for people to be able to communicate, whether that's with family or with legal representatives, and to have the digital means for that, where if it's a mobile phone, an iPad, something which, if they choose to, it's there for their sole use, to be able to contact people that would normally have that face-to-face contact with them.
That is all of the questions that I have for you. It just leaves me, I think, to thank you for your time today, and if His Lordship has any further questions, I'm sure he'll ask.
No, thank you, Mr. Inner. I would like to do one thing, though, and that is that I was very struck, Mr. Houston, by the evidence you gave that it was impossible in some circumstances during the pandemic for both solicitor and client to participate in one phone call because of the way the system was set up. You were, of course, very frank that you were only talking about Glasgow Sheriff Court. Can you make some, or have somebody make some inquiries to see if we've got any other evidence about, did the same problem exist in other sheriff courts?
Of course,
I'm not sure if we have any evidence. We might, but if not, see if we can find some. So apart from that, thank you all for your evidence. Very grateful. 2:45.
All right.
Mr. Turner, before you say anything today, the next witness is the Dean of Faculty, and he is, as such, the leader of the profession of advocate in Scotland. And I think it's appropriate that I make a public declaration in public interest that I am a member of the Faculty of Advocates, and therefore I have an interest as well as my interest as chairman of this inquiry. So I make that formal declaration at this stage. Good morning, Mr. Dunlop.
Morning, Lord.
Mr. Turner, when you're ready.
Thank you, my Lord. Good morning.
Morning.
Could you please state your full name?
Roderick William Dunlop.
And Mr. Dunlop, you appear this morning in your capacity as Dean of the Faculty of Advocates, is that correct?
That's correct.
And by convention, the judiciary and the legal profession refer to you as the Dean of Faculty, and if you are so kind, I'll continue that convention this morning.
I'm very happy for you to address me as you wish, Mr. Turner.
Thank you. Mr. Dunlop, you have, Dean of Faculty, you have given a statement to the inquiry. Is that correct?
I have.
My Lord, that statement is reference SCI WT 0556 number 1.
That is it.
Thank you. The entirety of that statement, Dean of Faculty, will be taken into account by the inquiry. We're going to touch upon some, but probably not all of that this morning in the time that we have, but the entirety will be considered by His Lordship in due course. You're here this morning representing the Faculty of Advocates. If I may, for the benefit, probably not for those in the room, but for anyone who may be watching, could you tell us who are advocates?
So advocates are I suppose, the Scottish equivalent of what is known in England and Wales and many other jurisdictions as barristers. We are the independent referral bar, in shorthand, the ones that wear the wigs.
Thank you. And how many advocates are there in Scotland?
Practising bar at the moment, around 450.
Thank you. And you referred there to the independent referral bar. If I could ask what that means, how do advocates receive their work? If you exclude direct access instructions, which is a very small proportion of the work and which relates only to advisory work and not litigation, all of our work comes as instructed by firms of solicitors, Scottish solicitors, who will then instruct counsel to act for them either in advising their clients or in representing them in court. Thank you. You've used the word counsel there, Dean of Faculty. Again, for the benefit of those who may not be familiar, what does that term actually refer to? So,
counsel would be another word used to refer to advocates in Scotland, barristers in the rest of the United Kingdom.
Thank you. And in terms of the work that's received from solicitors, excuse me, do advocates choose what that work is?
No, we don't. We are bound by the cab rank rule. So as long as instructions are tendered that are within your level of expertise and as a way of paying for the work, we are bound to accept those instructions. We don't go looking for work. We are dependent on the reference, hence the referral bar from the firm of solicitors in question.
Thank you. And do advocates work together in firms or otherwise?
No, every member of faculty is a sole practitioner. We're organised in terms of stables, which are I suppose, a loose equivalent of the English notion of chambers, but while as chambers are individual business units, as it were, stables are just organisations of advocates who are looked after by the same clerking team, but there's no actual business relationship amongst them. We all have to be sole practitioners.
And if advocates are also practitioners and they've effectively no interest in each other's business, how do they view each other?
Depends on the case, I suppose, but there's very much, always has been, and endures to this day, very much a collegiate atmosphere at the bar, where, so by way of illustration, almost all members of faculty contribute to a scholarship fund, which is used to help people who are deviling or training to become an advocate. So we all pay towards people who will become our competitors. And when they have become our competitors, you tend to look out for them in terms of If someone has a particular difficulty and someone asks you for help with a case, you will almost always willingly provide that. Not if they're on the other side of you, of course, but if someone's particularly in the Advocates Library and has a difficult question, a difficult problem they've not come across before, they are free to and indeed encouraged to approach other members of faculty to see if they have other ideas, bounce those ideas off them and get support in that way.
You mentioned their support for work, and you mentioned collegiality. Do members of the faculty offer any other kinds of support in the ordinary case?
Yeah, so the collegiality really is at the core and extends all the way through. So every member of faculty will have done a period of devilling, usually, but not always, one of 9 months. They will inevitably have a devil master. And the vast majority of members of faculty have a great relationship with their devil master that endures long after they've finished devilling and will often endure for life. So that's a first port of call. If you have a problem of any sort, you would go and speak to your devil master. You might speak to your peers, or if you had a particularly specialised case and you knew another member of faculty wasn't involved in that case, you would often just go up to them in the library or phone them and say, look, I know you're an expert on this. I haven't come across this before. What do you think about what I'm planning to argue?
Thank you. We've spoken about the advocates. If I could now just ask very briefly about the faculty itself. What is the faculty?
So the faculty is both the representative body and the regulatory body for advocates in Scotland. So we represent the membership if we need to, and for example in discussions with the Scottish Legal Aid Board, with the Scottish Ministers, with the Scottish Courts and Tribunal Service. We also regulate the membership, so if there are disciplinary concerns, they now need to be filtered through the Scottish Legal Complaints Commission, who will sift them out. But if the SLCC identify a conduct complaint, that is remitted for investigation by the faculty and will be prosecuted before the faculty's Complaints Committee and/or its discipline tribunal.
And are all advocates members of the faculty?
All advocates are members of faculty, yes.
You mentioned that advocates are the ones wearing wigs in court that people may have seen. Are advocates the only people who appear in courts in Scotland?
No. In the lower courts, solicitors also have rights of audience, and in the higher courts, so the High Court of Justiciary, the Court of Session, the Supreme Court, one will also often encounter solicitor advocates, or the appropriate term would be solicitors with extended rights of audience. So they are not members of the bar, but they have been deemed qualified via the Law Society of Scotland to exercise rights of audience in those higher courts.
We heard last week from the Vice Dean of Faculty, the President of the Scottish Criminal Bar Association, Tony Lenihan, on behalf of criminal practitioners.
Yes.
Again, for the benefit perhaps of not of those in the room, but for others, generally we have both criminal and civil business in the courts.
Yes.
Or do advocates, are they qualified to appear in respect of both of those?
Yes. So solicitor advocates need to be admitted either with extended rights of audience in the criminal courts or the civil courts, although the same individual can get both, but those are two separate qualifications. Once one is admitted to a membership of faculty and then admitted to the public office of advocate, which is done by the court itself, one has a right of audience in all courts, civil or criminal, in Scotland, from the district court all the way up to the Supreme Court of the United Kingdom.
In practice, do advocates appear or tend to appear in both criminal and civil matters? Much
less common than it used to be. When his lordship was in practice, when I started, it was much more common for people to do a bit of both. But really from probably about the time I was starting, maybe a little bit before that, so 1998. So in the 1990s, there came to be a greater degree of specialisation to the extent that nowadays you still find some generalists, and I remain a generalist, so I do on occasion appear in the criminal courts, although the vast majority of my work is in the civil. Most members of faculty will specialise now and will only do one or the other.
we've spoken about appearing in court. Is that the only work that advocates do?
No, a great deal of our work is advisory, so providing opinions either in the course of ongoing litigation or in advance of anticipated litigation.
Are there any, or is there any other work that advocates do other than court-related work?
Yeah, just general advice on any legal matter can come our way. The majority of it is linked to litigation, but it's not exclusive to that. And I mentioned earlier direct access. Direct access work we cannot act on a direct access basis if the case has been litigated. But certain people, certain organisations are able to instruct advisory work from counsel without involving a solicitor. It's a very small proportion of the work that faculty does every year.
Does the faculty get involved in alternative dispute resolution?
Yes, absolutely. Our members are often involved in arbitration, adjudication, mediation. That's fairly common.
And this may be self-evident standing where we are, but public inquiries?
Yes, and increasingly so, given the amount of public inquiries that are ongoing. We have members involved both in the UK COVID inquiry, also in this inquiry, and then the many other inquiries that are ongoing involving hospitals, Shaco Bio and the like.
If I could now, Dean of Faculty, just ask you very briefly about yourself a little bit. When did you join the bar?
I called in 1998.
And you are currently King's Counsel, is that correct?
Yes, I took silk in 2010.
And could you just explain again briefly, not for those in the room, what it actually means to be King's Counsel?
So once you've attained a certain level of years of experience, you are able to apply to take silk or to become one of His Majesty's Counsel. That requires you to apply to the Lord President, who then will take soundings from the rest of the judiciary as to whether or not you are suitable for that role. And having taken those soundings, the final decision rests with the Lord President and the Lord President alone. But he does take into account the views of, in particular, the judiciary. He also consults the Dean of Faculty of the day and others, and the Lord Advocate, for example. He will then, if he thinks it appropriate, make a recommendation to the First Minister, which is then passed to His Majesty himself. And in the event of that application process being successful, letters patent are issued, in terms of which one becomes a King's Counsel or a KC, and thereafter will operate as senior counsel. Cases don't require a KC to be run, but the bigger cases will almost certainly have a senior counsel involved, usually also with a junior, although juniors are perfectly entitled to run any case all the way up to the Supreme Court on their own without a senior. But most cases that proceed to the appellate stage will have a senior in them.
And you are currently the Dean of Faculty. Could you just explain to us what or who the Dean of Faculty actually is?
So Dean of Faculty is the leader of the bar, represents the bar at domestic and international events, represents the bar when, for example, having to give evidence to parliamentary committees, negotiates or discusses on behalf of the bar with stakeholders in the justice system, such as the Lord President, with SCTS, with the Law Society of Scotland. It's not in the same way as, for example, the Bar Council of England and Wales. The chair of the Bar Council of England and Wales is a salaried full-time position. So the person that is chair will take a year off practice. The Dean of Faculty the position is not remunerated, and it's not full-time. So you operate a normal practice as well as doing the work that's inherent in the role of Dean.
You say it's not full-time Dean of Faculty. How much of your time does it take up?
A lot. It does necessitate quite a lot of evening working in order to run a busy practice, while also covering the various things that come across one's desk, which are I think the most time-consuming thing is probably pastoral. We have an operation or we have a system in which, if any member of faculty is concerned from an ethical point of view about a case that they're involved in or a problem that they've got, then they're very much encouraged to come to me or to the Vice Dean for guidance in that regard. And if they do that, then they are obliged to follow the advice that I give them. The flip side of that is if they do follow the advice that I give them, then they're pretty much immunised from any complaint. Even if I get it wrong, it is likely that somebody who has followed my advice will not be liable to a complaint because they've done what the Dean of the Day has told them.
Are you supported in any way in your role?
Yes, other office bearers. So the office bearers now, we have the Dean, the Vice Dean, the Treasurer, the Keeper of the Library, Clerk, Deputy Clerk, and also the Chairman of Faculty Services. We meet on a regular basis. And the workload is very much shared across those office bearers. We also have co-CEOs, Fiona Burrell and Forresky, who provide a great deal of support along with their team, who are known as the Dean Secretariat or Regulatory Operations, depending on which incarnation you use.
And in terms of the office bearers, those are members of faculty?
Yes, all members of faculty.
And are they remunerated?
No.
Does the Dean of Faculty have any executive powers?
Executive powers in the sense of the running of, or the conduct of members of the bar. Is that what you mean?
Oh, I actually mean in terms of acting on behalf of faculty, in terms of spending or day-to-day operations.
Faculty used to be operated as what was often described as a benign dictatorship, and that the Dean of the Day could do what he wanted. That doesn't really work like that anymore. And I mean, if it was something fairly minor, I would make a decision on it. If it involved expenditure, I would almost always take that past the Treasurer first. It's really Ms Crawford's responsibility to decide where faculty's money gets spent. So if we're talking anything over a sort of £50, I would want Treasurer sign-off on that. I do, on occasion, make decisions or produce directions just on my own cognition, as it were. But if it's anything important, I would want to take with me as other decision makers involved in the process, either the office bearers as a body or faculty council, which is the sort of elected body that really is the executive arm of faculty itself.
When did you become Dean of Faculty?
July 2020.
And prior to that, did you have any role in the faculty?
Yes, I was Treasurer from 2017. In January 2020, the then Vice Dean stood down. I stood for election and was not opposed, so was appointed Vice Dean. Then the Dean stood down in June 2020. I stood for election, was again unopposed, so I was appointed Dean in June 2020.
We're going to speak in a
Sorry,
moment.
July.
We're going to speak in a moment regarding the start of the pandemic in terms of February 2020, March 2020 in
Yes.
particular. At that time, what role were you undertaking?
So February into March, I had just become Vice Dean of Faculty.
And in terms of the operation of the faculty, were you acting as Vice Dean at that time? What was happening with the Dean, if I can ask?
I was acting as I would expect to have been acting as Vice Dean in the run-up to the first lockdown in the middle of March 2020, and then in the immediate aftermath of that. But There was then an incident that was fairly well publicised involving the then Dean, which caused him to step back from matters to an extent, and an awful lot of the operational matters that faculty was interested in particular in terms of getting the courts back up and running, then fell to me to deal with.
We'll come back to discuss those matters in terms of the courts opening up in a moment. But if I could just, first of all, turn back to the profession. You spoke about devils and deviling. How do you become an advocate?
So one has to, the advocate requires two things. First of all, you need to be admitted as a member of faculty, and then you need to be admitted to the public office of advocate by the court itself. In order to get to that point, you need to have done a period of deviling, which, is, as I mentioned earlier, is normally 9 months, but can be truncated. So we've had two situations recently where solicitor advocates, i.e. Extended rights of audience solicitor advocates who had taken silk and become KCs as solicitor advocates, applied to become members of faculty. It is within my discretion, under advice from the Dean's Council, to reduce the period of deviling for both of those individuals. I reduced it to 4 weeks. They were both criminal practitioners, but they hadn't really done very much civil work, and because, as you've mentioned, once you're admitted to the bar, you can plead in any court. We thought it appropriate to require examination in civil work and also a 4-week deviling period in civil work, but they only had to do 4 weeks. The vast majority will do it for 9 months. So you matriculate by presenting a petition to the court. Once you're a matriculant, you can start your deviling. In the course of that deviling, you need to pass a number of exams, and you will shadow a junior member of faculty. If you get through those exams and your devil master passes you as competent, then you will be admitted in a ceremony which nowadays almost always takes place in June, in which you'll be admitted membership of faculty, then admitted to the public office by court, and thereafter you don the wig and gown and you can practice as advocate.
Just to be clear, although you've mentioned there are 2 steps in terms of admission as a member of faculty and then admission by the court, is there any separate qualification for those 2 things?
There's not.
And you mentioned shadowing a junior member of faculty, and you've also mentioned devil masters earlier in your evidence. How do those 2 things relate?
So the person you're shadowing will be your devil master. These days, you will almost certainly have more than one. And again, if we went back several decades, most people will only have 1, possibly 2 devil masters. But now, because of increasing specialisation, you will almost certainly have 2, at least, a civil and a criminal devil master. You may well have more than that. So you may well spend some time with, for example, a family practitioner, some time with a personal injury practitioner, sometimes with a commercial practitioner, and always sometimes with a criminal practitioner. And
you've mentioned that members of the bar are qualified on both civil and criminal. Are they therefore required to undertake training in both sides?
Indeed.
You've mentioned the requirement of an examination and shadowing of a junior member of the bar. Does the faculty itself offer any training?
Yes. So once you start deviling, which will be in September, the first thing you do is a 5 or 6 week foundation course, at which you receive intensive training from a variety of members of faculty, all of whom give their time for free to assist in that. The director of training is remunerated, as is the deputy director, but everyone else that's involved in that is just gives their time for free. So that 5 or 6 week foundation course sets you up, and then you will be released to your devil master and will shadow them. There will then be a further skills course, usually in the January. You'll sit assessments in the February. Those assessments will be in written pleadings and in opinion writing, also in legal argument and in cross-examination. We'll come on to the pandemic in a moment, but traditionally, where does that training take place? The Mackenzie building is where most of it takes place, which is situated on the Royal Mile, just down the road from down the Royal Mile from Parliament House. But increasingly now, SCTS are prepared to give us access to actual courtrooms for some of the training, in particular for the mock court exercises.
And likewise, in terms of shadowing or other time away from formal training, where traditionally would devils have spent their time?
I'm sorry, say that again?
Where would devils have spent their time during their training 9 months if they weren't in formal training?
If their devil master is in court, then with their devil master, whether that be Parliament House or at one of the many sheriff courts or high courts sitting around the country. And if they're not in court, then they will either be working from home or more often they will be in the Advocates' Library.
Are there any costs involved in joining the faculty?
There is an admission fee for the there's a court fee for the petition to be matriculated. Thereafter, there are no fees until you actually are admitted to faculty, and the payment of those fees is deferred or staged. I can't remember which over I think the first 3 years of your practice.
How do you know off the top of your head? You maybe don't, Dean, but do you know how much those are?
I'm afraid I don't. That's very much the Treasurer's remit.
You mentioned members of faculty paying into a sponsorship scheme.
Yes.
Has that always existed?
It's not. So historically we had 2 scholarships, and by which I mean effectively 2 scholarship awards, both funded by bequests that had been left by former members of faculty. So with the Lord Reid Scholarship, which was and still is given to the person deemed to be the outstanding scholar for that year of Devil. And we also have the Faculty Scholarship, which has an eye on excellence, but was also is weighted to people from a more disadvantaged background. But those were the only 2 scholarships, and we decided that really wasn't good enough in terms of widening access to the profession. And so in 2017, after I'd taken office as Treasurer, I proposed to the membership that everyone would make a contribution from the fees that they earn, as a percentage of the fees that they earn every month, on an opt-out basis. So it is voluntary. You can opt out of it. I think out of the whole membership, only 3 people opted out. So that then set up what we now call the Lord Hope Scholarship, named after one of the former Deans of Faculty and latterly Deputy President of the Supreme Court. And last year, the now Treasurer, Miss Crawford, proposed that the amount that people contribute by way of percentage be increased, again with no opposition and no opt-out. So I think for the last year, everyone that asked for a scholarship got a scholarship.
Again, it may be a matter for Ms Crawford, but do you know how much the faculty pays out in that?
I think it's in the region of 100 to 120,000, but that's, you couldn't hold me to that, but I think that's ballpark.
I'm going to come on to talk about the effect on the bar in terms of lockdown, etc. in a moment, but just before we leave Devils, was there any impact on Devils and training caused by the pandemic?
There was. I mean, obviously, I remember this vividly because one of my now wife was one of the Devils that year, and their deviling had proceeded normally from September through to March, but then when the lockdown hit, there was inevitably a hiatus and nothing really was happening. There was still written work around, but for the first month, nothing was happening. And even when things started to get ratchet up a bit, as doubtless you're coming on to, it was slow. So a lot of the Devils were just kicking their heels. And as a result of that, we approached the Lord President and asked that the Devils be allowed to call slightly earlier than would have been the case. They should have called in June. we allowed them, with the Lord President's blessing, to call in May, just so that they could get out and try and start earning some money.
And in terms of that, that was the year, effectively 2019, 2020.
Yes.
There would have been a further year coming in September 2020, is that correct?
Correct.
And were they able to do their deviling in the traditional manner?
No, their year, and it was a small year as a result, because it was known that the pandemic would continue to have an impact on it. So quite a few people that were meant to start in September 2020 delayed for a year, decided not to come that year. So I think we only maybe had 6 or 7 that year, and their deviling was almost entirely online, because things hadn't opened up in the way that it would subsequently do. So they would have got to go to the criminal cases that were running, but for the civil work, because it was pretty much entirely online, certainly the foundation course was entirely online, the skills course was entirely online. So many of those people, well, in fact, that bunch of devils that year, they met each other in person once at the beginning, when we had a socially distanced introductory session to explain how it would be, and then they didn't meet each other again in person until they actually called.
Do you think that had any effect on their deviling period?
I think it must have done. They seem to have managed to maintain the same collegiate bond as one would expect. You tend to find that people that devil with each other they will become friends, and they will look to those people for support. And I think you can still see that for that year, but it will have been more difficult for them to form that bond in those relationships when their interactions were always and entirely over screen.
You've mentioned that they would have had access to criminal trials, but potentially less so in terms of the civil side. Again, do you feel there was any detriment in terms of that? The fact that justice was done so much over online was necessary. And in many ways, it kept the justice system going. You couldn't have done otherwise. But personally, I consider it suboptimal. I think that advocacy is all about humans trying to persuade other humans, and you need human interaction. I think some of that is lost over the screen. And over and beyond that, I think it's very important for people who are trying to build a career, especially at the bar, when you're reliant on instructions from firms of solicitors to be able to build up human interactions. So historically, you get instructions from a solicitor, you go into court. If it's in the morning for a half-hour hearing, you'll go for a coffee with them afterwards, and you'll build up personal relations that way. If it's a long case, then you might go for a beer after court with that solicitor. Again, you build up the personal relations. When you're online, you log on, you're the only face on screen. Your solicitor's face isn't on screen because they're not actually appearing as such. They're just a name. When the case is closed, the clerk closes the screen and you're still sitting in your house. The ability to build personal relations was very much impacted by that time. In terms of instructions, you mentioned building up personal relationships. In terms of instructions, we mentioned the cab rule, we've mentioned stables. In terms of instructions to advocates, particularly on the civil side these days, how are those received? Are those received directly by advocates, or did the stables get involved?
Could be either. So instructions could either come in to your clerk saying, I want to instruct Ms. X for this case. Clerk will then pass that on. Instructions could come into the stable just saying, I need an advocate to do this. Who do you have? And the clerk would say who's available and who might be good for that particular case. Or quite often, a solicitor will just send instructions to you directly, especially now. Almost everything is done electronically now. Obviously, massive increase in electronic paper since COVID. So it is quite common for a solicitor just to instruct you directly saying, can you do this? Usually what I will do then is say, can you liaise with the clerks and make sure it gets put in the diary properly, but quite happily liaise with the solicitors over ability to attend to the work.
In terms of what you said then, Dean, in terms of the choice of advocate, that's ultimately the solicitor's choice. It's
ultimately the client's choice. The client will usually follow the advice of the solicitor, but if the client says, no, I want X advocate to do this case, even if the solicitor says, I'm not sure that's the right fit, if the client insists, it's the client's choice.
Thank you. I'd like to talk to you now about the changes to the bar, or indeed in the bar's business, I suppose, in terms of the pandemic. Before we talk about the courts, if I could just very briefly ask, did the faculty have any plan in place for something like the pandemic?
No. I'm afraid the impact of potential global pandemic was not on the radar of the Faculty of Advocates.
Did the faculty have IT provision that would facilitate people working at home?
Not expressly designed for such, but we have a very good IT department who were able to assist pretty rapidly as it became apparent that this was not going to be a week-long lockdown and we were going to have to adapt our ways of working. So our IT department were excellent in that regard.
You've mentioned that advocates are independent practitioners. Does the faculty dictate what services or what equipment individual members might be using? No,
it's up to each member. Was there anyone at faculty that didn't have a laptop in 2020? Probably not. We do still have one or two members who prefer to write out opinions in manuscript. But I think even they would have had access to a device of some sort. We do, most members of faculty are subscribers to Faculty Services Limited, which is a service company that employs, for example, the IT team. The IT team would provide support to any member of faculty, whether or not a subscriber to FSL, especially in the wake of the pandemic. And they were able to give guidance as to what sort of equipment would be necessary if you didn't have the right kit.
Did many members require that kind of assistance?
Not a huge number. Most were fairly IT literate, but there were quite a few that needed help with getting the right equipment for, in particular for WebEx hearings, Zoom consultations and the like, because they simply either they had a very old laptop that wouldn't work with it, or they needed better spec kit to run the video conferencing.
I'd like to talk to you now about the changes to the court in particular. A pivotal date, just to plant ourselves, if I may, is the 23rd of March 2020, which was the date that the first lockdown was announced. In advance of that, Dean of Faculty, were you or were the faculty expecting any decisions to be taken in terms of the business of courts?
We were watching very carefully what was happening from, I would say, from January onwards. But I think my recollection is I was still pretty much surprised or almost shocked when the news came in that we were actually going into lockdown. I've perhaps been overly optimistic about things and thinking that will be all right, it's not going to happen, and then it did. I do ask myself whether or not there were steps we could have taken. I don't think faculty could be blamed for not anticipating a pandemic before January 2020. Were there steps we could have taken between January and March? Possibly, but I'm not really clear what they would have been. Certainly, I don't think there would have been anything that would have been very different. We might have been able to get slightly ahead of the game for our members who weren't fully IT literate, saying you might have to be prepared for working from home in a way that you're not presently. That's really the only thing I can think of that we might have done in that sort of 6-week, 8-week period.
I appreciate at that time you were the Vice Dean of Faculty, and therefore you may not have been the point of contact, but are you aware of the faculty having any discussions with the courts prior to lockdown? I'm
not. The first awareness I have of anything in that regard was, as mentioned in the witness statement, the night of lockdown when I had to speak to the judiciary.
And as you said, you've mentioned in your statement that you were, I think, due in court the following day. Who were you due to appear before?
That was meant to be in front of the First Division of the Inner House for an appeal. The decision at first instance had been made by now Sheriff Principal Ross. A leapfrog appeal had been granted, so the Sheriff Appeal Court had sent it directly without a hearing to the Inner House. And it was meant to be before, I can't remember the three judges involved, but certainly the Inner House chaired by the Lord President, Lord Carlaby.
Again, not for the benefit of those in the room, just to pick a couple of terms there, you mentioned the Inner House. What is the Inner House?
The Inner House is the Court of Appeal, Civil Court of Appeal for Scotland.
And who is the Lord President?
Lord President is the senior judge in Scotland and the head of the judiciary in Scotland.
Thank you. What did you do once you heard there was lockdown?
I was unclear as to what I should. It happened from recollection. It was announced in the evening. And my then partner, now wife, said, "Come and look at this." I was preparing for the next day's hearing at the time, and I wasn't really sure what to do. So I thought, well, I'd best try and find out what does this mean for the courts. I didn't have the sort of direct channel to the Lord President, which I would attain as Dean. And I didn't know how to get hold of the Lord President, but I did because I'd junior to him on a number of occasions, have the contact details for Lord Pentland, who, as it happens, is now the Lord President. So I phoned Lord Pentland and said, any idea what's happening tomorrow? He gave me the contact details for the Lord President, and I just phoned him directly. And as I've mentioned, the initial reaction was, I don't think this applies to us. I think the courts will still be running. I spoke to my opponent for the case the next day, who expressed some concerns as to whether or not that was safe, given everything that was on the news. I went back to the Lord President with that message, and he said, well, on that basis, it's off. And we'll see what... We'll be back in touch over the next few days to work out what we're doing next.
Just to be clear, when you're saying, or where somebody is saying, you're not sure that this applies to us, who was actually saying that?
That was the Lord President's initial reaction. I don't know why that was, but his initial reaction was there are work-based exemptions, or there will be work-based exemptions for this. That will apply to us, so I don't think there's any necessity for this not to go ahead.
But it was ultimately discharged.
Yeah, I mean that position lasted all of half an hour, because when I went back with my opponent's concerns, Lord Carlaby said, look, if anyone's worried about this, I'm not going to make it happen, so we'll put it off, and then we'll have a better understanding of how this is going to work with the courts. And as you know, it basically meant the courts were closed.
We've spoken, as I said, to the Vice Dean last week, so I'd like to ask you, he had spoken to us extensively about criminal side of practice.
Yes. So
if you don't mind, I'm not going to ask you a great deal about that, but I would like to speak to you about the civil side of business in the Court of Session. So as of 23rd of March 2020, work had stopped. Is that correct?
Yes. But not all work, in that obviously if you were still being asked to draft pleadings or attend an opinion, then that was fine. But as soon as lockdown hit, we closed the entirety of the faculty estate, so the consultation rooms were closed, the advocates' library was closed, at least in the first instance. The courts were closed, so everyone was very much staying at home until we worked out how we were allowed to allow people to go back into, on the restricted basis, back into the library and ultimately into courts.
Again, looking at the immediate period, let's say the week after the 23rd of March, was anything happening in the courts?
Nothing at all. Nothing at all in terms of the... Well, actually, that's not true. I think there was still a trial. I can't remember when the last trial to sit before lockdown was the Alex Salmon trial. I can't remember whether that lasted after the lockdown or finished just before it.
If I may interrupt, it did. It lasted about a week.
Thank you, my lord. So that would have been I'm pretty sure for any ongoing criminal trial, and there must have been ongoing criminal trials, there would have been runoff. They wouldn't have pulled the plug on an ongoing criminal trial. But as soon as all the criminal work, or as soon as all those criminal trials had finished, there were no new ones taking place in the wake of the lockdown.
So we've got some criminal business continuing, but on the civil side, business had ceased.
Yes.
The courts were effectively, to use, I think, a word that you once used, Dean of Faculty, mothballed.
Yes.
To your knowledge, was there a plan for recommencing work? At that time, was there a plan for recommencing work?
Well, there wasn't immediately on the 23rd of March, but there very quickly would come to be one. And indeed, in preparing for this statement, I realised it had gone far more quickly than I had thought. When the witness statement was originally taken, I was pretty sure that the courts didn't get back into the online working until June. I see from my diary I'm entirely wrong about that, and in fact they recommenced in April. So within a month, we had moved to online hearings, albeit on a very, very much staggered basis, starting with the inner house, then the outer house, then the sheriff courts.
You've said in your statement, I think, that you actually appeared in the first hearing in the inner house. Is that correct?
I did. In fact, I did two. I backed one day and one the next. That had meant to be happening in the week when lockdown was announced, and they happened back to back in the middle of April. And the first one to happen was the one that had gone off as a result of the conversation I had with the Lord President I mentioned earlier.
And I think you say in your statement that was the 21st of April, is that correct?
Yes.
If I could just take us back a few weeks before that, we have lockdown the 23rd. Again, just in terms of orientating ourselves, the Coronavirus Scotland Bill was published on the 1st of April 2020, which made some proposals in terms of the criminal courts. Did you make any comment on that bill in relation to the civil courts at that time?
Not to the ministers. My discussions, I would come to have regular discussions with the ministers, but at that time the point of contact was entirely with the Lord President and or Eric McQueen, who at the time was Chief Executive of the Scottish Courts and Tribunal Service. So the vast majority of my discussions were with those individuals, although, as I say, I would come to have discussions with, in particular, Ash Regan, Minister for Community Safety at the time.
Did you make any public comments about the civil courts at that time?
Possibly. I can't remember. If you have access to my X feed, you may see I may have said something on it. I'm not sure.
Might you have made any encouraging statements, encouraging reopening of civil courts at that time?
I'm sure I will have done. It was a bang. A drum I was banging on a fairly regular occasion.
Did you think the courts should be reopening quickly?
Yes, I was very keen because of the need to get my members working, of the need to avoid the endless delays in the justice system. I was very keen to get it back up and running in some form. I always, as I've mentioned already, prefer in-person hearings, so I was very keen to get them back in as soon as we could. But I had to recognise that others were better placed than me to take a view as to the risk-benefit analysis.
Were you aware of any particular reasons that were preventing courts reopening at that time?
I think it was just the deemed inadvisability of having many people in one place at a time. Many court buildings are not particularly well suited for social distancing.
Hearings obviously commenced. You've given evidence that hearings commenced remotely. Were you aware of anything that was preventing remote hearings commencing at that time?
It was just the need to get the system in place. SCTS pretty much immediately went into action to get the WebEx platform up and running. I don't think there had been an identification of that system before. My recollection is that it was in the wake of the 23rd of March that we were being told they were investigating platforms and that WebEx was the favoured one. That then had to be road tested. The judges had to be, their homes had to be fitted out with the appropriate tech. For some of them, they needed to have their internet provider upgraded, usually hardwired rather than Wi-Fi, to ensure stability of connection. And that was what was being attended to, with a focus on the appellate judges, those in the inner house, in the first few weeks post-lockdown, in order to get the systems ready for hearings starting in April.
You've mentioned that advocates are involved with the preparation of papers for court. Traditionally, how are those papers provided to court?
Do you mean pleadings and the like?
Indeed.
Yeah. So some of us have been working almost exclusively electronically for some time. I think I've been working electronically since 2013, 2014. But certainly pre-pandemic, many members would still be working hard copy. And by that I mean when they receive their papers, they would receive them in ring binders. And when they send back the product of their work, they would send back something that had been typed out, printed out, and then signed in wet ink. Whereas nowadays, almost everything is certainly sent digitally, often signed digitally.
How was the court receiving papers?
Hard copy, although latterly it had, especially in cases involving more bulky papers, the court had started to move to electronic papers. Again, post 2014, that was being accepted, but depended on the bench that you had. So you could easily have a case where you provide a memory stick to the court, and the court would say, that's very interesting, but Lord X and Lord Y are sitting, they would prefer hard copy, could you print those out, please? Post-lockdown, it became the protocol that they wouldn't accept any physical papers, and all papers had to be produced electronically.
Again, in that initial period, did the existence of those papers being in hard copy cause any issues to your knowledge?
No. We very quickly, everyone just moved to electronic. It did mean that some people had to become more familiar with Adobe Acrobat and the like that they'd been before, but that's quite intuitive.
Again, to your knowledge, you may not have knowledge of this, Dean of Faculty, but to your knowledge, was there any delay in the inner house commencing business because papers were in hard copy?
I'm not aware of that.
Did you at any time make any suggestion that electronic copies might be provided by agents directly to the court to assist them?
I think that was, well, I mean, that's what would have happened anyway. Council never provide papers directly to the court. It would always be done via the agents.
In substitution for the court's copies, though, Dean of Faculty, would you have suggested, or might you have suggested, that agents could, if the court was not unable to access its own copies, that agents could provide copies to them to allow hearings to commence?
I may well have done.
You've mentioned a couple of times that this was, again, I think to use your words, the least worst option in terms of remote hearings.
Yeah.
Excuse me. Did you have any discussions with bars from the other nations in the UK regarding that?
I did. We were so we regularly meet. So the chairs of the Bar Council of England and Wales, Ireland and Northern Ireland, and myself meet regularly. Obviously, we were at that point in time meeting online regularly, and all of us had concerns at the lack of pace being seen in getting back to in-person hearings. Some of us thought that some of the judges were overly keen on remote hearings and indeed would like to see those endure. And so I think I provided this to the inquiry. Ultimately, a joint statement of the 4 bars was put out urging the courts to return to in-person hearings, certainly for cases or for hearings that were potentially dispositive, i.e. which could result in a decision one way or the other that would determine the case. We were all firmly of the view that such hearings should be, where possible, in person.
Does that remain your view?
It does.
And in terms of the current practice of the court, has the current practice changed or been sustained from the pandemic?
So obviously for the first year or so, it was civil business was entirely online, with one exception, a case I mentioned in the statement in the autumn or winter of 2020, which, because of acute questions of credibility and reliability, did take place in person. Everything else was taking place remotely. Gradually, the courts started to open up following Lord Carloway asking Lord Pentland to chair a review group and to take soundings from the profession as to the extent to which, if at all, hearings should remain online. And now we've arrived at the period at a point at which most hearings will take place in person. Certainly anything that's of any importance or potentially dispositive of the proceedings. Procedural business is still, a lot of it is done online, but some of the judges are trying to move away from that and encouraging even fairly short procedural hearings to take place in person. Although they are being very reasonable and flexible about that. And if you've got a situation where someone's going to have to travel from Glasgow or Perth to do a half-hour hearing, that will almost certainly take place online.
Dean of Faculty, I'm conscious that we are coming towards the end of our allotted time. I'm going to give you an opportunity in a few minutes, if there is anything that you particularly want to raise with his lordship that we haven't had time to cover. I dare say we could be here for several hours addressing matters. I just want to touch upon one final thing before I do that, and that is in respect of the members of the bar. You've mentioned the members are effectively individual sole practitioners. You've mentioned the collegiality of the bar. Notwithstanding that, could you give his lordship an indication of the effects of, in particular, lockdown and the pandemic on members of the bar?
Yeah, collegiality maintained, and people were very willing to chat to each other over email or phone. But obviously you were deprived of the ordinary ability that your lordship will fondly recall of taking someone for a coffee at the reading room and saying, right, what do you think about this? So that was more difficult, and we had to encourage fairly regularly via messaging to the members, look, remember we're still there. If you need to speak to someone, you need to speak to an office bearer, you need to speak to your devil master or your pals, then just phone them. Because it was a very isolating experience, as everyone in the world will remember. So that led to us having an increased focus on well-being, because we were concerned about how isolating that would be. And we've made various changes. We've expanded the remit of our well-being committee, which meets far more regularly. We'll have regular events. There's one in the Advocates Library tonight, as it happens. We've got a well-being officer. So all of those things were prompted by concerns that we had about well-being in the course of the pandemic. The collegiality was as strong as it's ever been, I think, but it was just more difficult to put it into practice.
Were there any particular incidents or effects that you recall during the pandemic in terms of the effects on members?
Well, I can't. We had 2 suicides. I have no idea whether or not those were contributed to by the isolating effect of the pandemic. Personally, I have to think it would have played a role, and that was very much part of the impetus behind the sort of enhanced focus on well-being.
Were there any financial effects on members?
Financial effects on members, in particular for the criminal bar, yes. The Civil practitioners had managed to keep working pretty regularly. I'm not saying that no civil practitioner suffered financial impact. I'm sure they did. For the criminal bar, it was horrendous because you'd gone from a situation where you would get regular payments from the Legal Aid Board because they pay quickly. In Scotland, they pay within 14 days. But that means you don't have a reservoir of fees, of unpaid fees. And all of a sudden, the work had stopped and the work wouldn't start for 6 months. So we were very worried about the financial impact on the criminal members. And as a result, we set up a hardship fund, which was voluntarily contributed to by members of faculty, donating between 5 and 10% of their earnings into that fund, which set up a large amount of money. In the event, only one, possibly two people called on that, and only then to get assistance with one month's mortgage payments. I think that's largely down to pride rather than as a result of it actually not being a problem. A lot of members were under real financial pressure, which led to the efforts of, in particular, the now Lord Ranucci, then Ronnie Ranucci, KC, QC would have been then, the Vice Dean of Faculty, criminal practitioner, along with Tony Lennon, from whom you've heard, having the idea to get the cinemas up and running, and that then allowed people to get back to work and get to back to work on a very busy basis because of the backlog. So we managed to get through that 6-month hiatus, but in that 6 months I was worried about the criminal practitioners.
Thank you. We've run over slightly our time, Dean of Faculty, but I am going to give you the opportunity that I gave you. If there is anything that you particularly like to highlight to His Lordship, now would be your opportunity.
No, I'm very grateful. It's very much as per the statement. There's nothing really I want to add in addition to that.
Thank you. Nothing further to add. No.
Thank you very much, Mr. Dean of Faculty.
Pleasure.
Thanks. There it is. 1:45, I should have said, ladies and gentlemen.